Stay tuned for Legal Straight Talk.
Okay, I need my kaleidoscope of colors to lead the way. I'm riding in my car and I'm coming on around the bend. It's a chase, this twisted race, I'll be on top again. Gonna be the whole 9 yards or nothing.
Okay. Say what you want.
Welcome to Legal Straight Talk. I'm Brett Harrison. And today, again, we brought back Al Hedayati to talk more about divorce and family. Thanks for coming back again, Al.
Well, we had so much to talk about last time, Brett. I figured I'd come back, answer more questions, help out people that are definitely going through difficult times or have family members that go through these difficult times regarding family matters and issues. And I'll be happy to answer any questions that you may have to try to help the listeners and the viewers out there.
You know what? Let's talk about child custody. And let's assume, for our example, the child is 12 and under.
You just like to get right to it, Brett, don't you?
I want to go right to it.
Okay, so
that seems to be, unfortunately, a pawn that's used a lot, whether there's 1, 2, or 3 children.
Okay.
Now, how does that work? You know, a lot of people assume, I always hear, oh, from a guy, well, you know what? They always give the child to the mother, and I don't even think the mother is necessarily as fit. Is there some type of presumption? Or the wife, a lot of times, will say, it's my child. It's obviously, I'm going to get custody. And both of those are wrong. Am I correct?
Well, you know what, Brett? The best response to the question like that, and we get it all the time from clients, usually the husbands say something like that.
But so do the wives.
Or the fathers, because this is custody. You don't have to be married to have kids. So, it could be, father, mother, or husband, wife. So, times are changing. That's my response. And judges are, beginning to, obviously, as women, I think the last time we spoke about equality as well in the workforce, between men and women. And that's also having an impact because, 20, 30 years ago, the women were taking care of the kids, raising the children. So obviously they would be the better. It was the Leave It to Beaver. Yeah. So it was they're more fit to raise children because, the courts are going to look at who goes to the doctor's appointments. Who do the kids call if something happens in school and they go to the nurse? Who do they call first? So, that's what they go by. Now, as times change, what we're seeing more and more is fathers can also have the same. Because if the father or mother or husband and wife are both working, usually kids either go to after-school programs or, something before they get home.
So what is the concept now then, instead of this presumption that the wife is more fit or that the wife will have it, is it now more who is the primary caregiver? That's another phrase I hear. That's
all it is, primary caregiver.
What does that mean?
So it's not who is more fit. Primary caregiver means exactly what I just went through. It means who's going to be, you go to who do the kids call when they get sick? Who do the kids call when the nurse's office calls? Who do the kids go to doctor's appointments with? So these are all factors. Now, it doesn't mean, you see, the good thing about this area of family law is that it's very fact-based. So, depending on the circumstances, fathers can very easily get custody of their children, depending on, who the mother is or what kind of a situation the mother has. Maybe the mother works night shift. If a mother works night shift and the kids are home, so how could that mother have custody? So the other thing I wanted to talk to you about is custody. The word is a little vague and ambiguous in that in the courts in New York State, you really have two separate types of custody. One is physical or residential custody, is where the kids reside or they live, what address do they put in their school, and the other type of custody is legal custody, which is basically decision-making, health, education, and general welfare of the kids, making decisions on those types of matters. So you really have two different...
So when you say custody, your first question is it physical, legal, or both, or joint?
Or joint. Well, yeah. Sole custody. I mean, what does that mean?
Okay. What does that
And
mean?
it's, sole custody means one parent has custody. But does it mean physical/residential? Or does it mean a joint legal or sole legal custody, which means the other parent has no say in health, education, and general welfare of the child? So, generally these types of agreements will be written by attorneys. And if the attorney knows what they're doing, and they've been doing this area, they're going to be as specific as possible as to what will suffice as joint legal custody, let's say. Usually, in order to keep the peace in New York State, you always say both parents have to know and be apprised of any, again, education, health,
When you
or general
say
welfare
apprised,
issues.
what is that?
The one parent, the first thing is, who are the kids going to live with? If the kids live with the mother, then obviously the school is going to contact, the house or the mother that they live with. Now, it's the mother's responsibility to contact the father and say, our child just was injured in school. I'm taking them to this doctor for a checkup on this. So,
Okay.
a lot of times, obviously, parents don't do it out of spite. They're pissed. They don't want to tell the
Well,
other
they don't
parent.
want to deal with the other. I mean,
They don't.
What, can the school say, okay, I'm under orders that if the father calls or the other
Well, exactly. So the other thing is,
non-custodial parent?
both parents, exactly. So custodial and non-custodial it's very interesting, and there's a lot to talk about when it comes to that. Now, custodial is the parents that the kids live with.
Right.
However, non-custodial would be the other parent, and that's really for purposes of child support. Who is going to be obligated to pay child support to which parent? And the non-custodial parent is the one that will be liable or responsible for paying child support to the custodial parent.
Now I want to go into one thing about child support. Just because the child doesn't live with you does not mean, in my understanding, correct me if I'm wrong, that the custodial parent's salary still gets factored into how much,
Well, we've had a lot of interesting case law on this, and I don't want to be,
How does it
start
work? How does it
speaking
work?
way too much legal jargon. But the two salaries are added up, then divided by the share of each parent, and then basically what you should look at to make it very simple
Okay.
for the viewers and listeners out there is the non-custodial parent will be responsible for a percentage of their gross annual income. Now, that percentage depends on the number of children. If they have one child, it's 17%, two children, it's 25%, so on and so forth.
Is that standard?
That's
just the way it
standard.
is?
They could
One,
deviate from that number based on the lifestyles,
or special needs?
Special needs, certainly. But that doesn't include the add-ons, okay? Because you're going to have after-schools program, you're going to have sports for the kids, you're going to have music lessons, language lessons, whatever.
Is that
But
you,
that
you
would
want
be
to put them prior to being divorced or separated? If the child had the aftercare, the music lessons, the sports camps, the summer camps, band camps, vacations, whatever, is that what they try to keep the child a similar situation, or?
Well, that's exactly it. The only thing that you really focus on when it comes to children in New York State is the best interest of the child. Forget about the desires or the wishes of the parents. You
Right.
said something before we talked about if something happens to a child at school, and does the parent, residential or custodial parent, inform the non-custodial parent? And if they don't, if that's a pattern of behavior, it will be considered what's called parental alienation. So if you're trying to keep the other parent out of the loop, guess what? You could lose custody. And if it's a pattern of behavior where the one parent is constantly disparaging the other, then you're going to have a very strong case. And like I said, these are very fact-based cases. So every case is not impossible to get it if you have enough evidence. I would say text messages, emails.
Or violating a court's order.
Violating the court's order.
If the judge says you better stop or else, and you're back again for the or else, and then back again, does there come a point when the judge says, you know what, I've had it. You don't care what I have to say.
Absolutely.
You know what, I'm limiting it now to this. Keep pushing me, and you potentially could lose custody.
And
physical
that's
custody.
the major thing that parents don't understand, and it happens way too often. And it's unfortunate because you know what? At the end of the day, I hear this every day. Well, the other parent, I don't want to say husband or wife or mother or father, it happens both ways, has been disparaging me, brainwashing my child. My child doesn't even want to see me anymore. Now you're talking about things that you could address in court, but they will certainly get costly because, you could have a forensic psychologist evaluate your child.
When you say forensic, explain to the audience what that actually means, what the cost is, and the purpose of
Well,
the
here's
forensic.
the thing. Whether you're in family court...
And who chooses this?
Well, whether you're in family court or Supreme Court, and if you have children and you're going through some family difficulties, you are going to have what's called a law guardian, either appointed or assigned. Now, appointed means the court's going to pay for it, and generally in family court, the courts will pay for it. However, in Supreme Court, they will not. So the parents will be responsible for the fees for this law guardian or guardian ad litem who represents the interest of the kids or children.
Who picks that guardian?
The judges do.
Oh, so you have no say?
No, and usually they have, they have a lot of, their decision carries a whole lot of weight.
Do they write a report? Do they visit the house? What do they do?
They visit the house. I've had complaints that, they wish that the law guardians were, they've got so many cases, but they do meet and they do discuss issues that arise out of, any kind of disputes between the two parents. They try to be a mediator. I've had law guardians try to mediate an entire divorce case because they're like, they're not going to feel bad for the father, not going to be bad for the mother.
It seems like they're
it's all for
overstepping their bounds, though.
But sometimes as attorneys we consent to it if we believe that it will get the two sides to understand one major concept, and that's best interest of the child or children. Because a lot of times parents forget about that easy concept. You want to move your kid from this school to another school because it's better for you. You could get closer to your job or something like that. Now, don't forget, is that school at least equivalent or better than the school that the kids are in? Because now you're taking your children away from their friends, what they're accustomed to, and their normal environment, and you're making it about you.
Well, let's say the school, let's say you live in Mineola, and you want to move out to Riverhead. Seems unfair to the non-physical custody
or the non-custodial parent.
Yeah, I mean, it seems, well, wait a second, now I got to, instead of typically being only 5-10 minutes,
well,
now I'm like, an hour and a half.
In that type of a case, Brett, I could see, the parent living in Mineola, living where they live, they have the kids. That's a very strong...
Or is it about having a lawyer that senses potentially that could happen and saying, let's put in something called a radius clause?
Well, there are radius clauses in most agreements, whether it's between 20 and 25 miles away. But, that's...
What is a radius clause for the audience?
Well, it just means that the parents, the custodial parent can't move within a certain mileage distance, right, from where they're living currently. So,
and if they want to, they then either have to get written consent.
They have to get the other sides or the other parents' consent or a court decision, right, a court order.
Huh. Because that seems to happen a lot, too, that one parent says, well, I have a great opportunity.
Well, then you could relocate. Nobody is saying you can't do what's a good opportunity for you, but that does not mean taking the kids out or away from the other parent, because that could also lead to parental alienation. I mean, if we have these cases quite frequently where one parent decides to move to Florida for a job opportunity, and what happens, Brett? What happens is, they go down and they think they're entitled because they're the custodial parent, and a lot of times they'll get shut down because it's just not sufficient for a relocation application. The reason is, you're going to have to prove a lot. Now, a lot of times, what happens? People say, I'm moving for my boyfriend, girlfriend. They don't say it, but they're saying it's a job, but it's really a boyfriend or girlfriend. And if we catch on to something like that, then, then the chances of a relocation are even slighter. You can ask
for a hearing or a stop from the judge?
Oh, absolutely. We're going to file an order to show cause to try to get it in court immediately, to stop them from being able to, relocate the children. Again, as an adult, you can go wherever you want, but that doesn't mean you can take, the other parent's children away without him at least getting his, opportunity to be heard in court.
Now, going back to the law guardian, does the law guardian get to speak with the child separately and apart from the parents? Because sometimes a child will say more separately.
Well, here's the thing, Brett. Sometimes even a judge sees the kids alone.
Really?
It's called in camera. So the judge will want to talk to the children.
Why would the judge want to do that?
Well, because this is, anytime you have family disputes, judges know nothing he says is 100% accurate and nothing she says is 100% accurate. So she wants to hear from the kids themselves about what's going on in the house. And, again, I've had clients that say, well, he or she has manipulated the children, so what they say isn't accurate. But, you sometimes you got to put your money in what you believe in. And if you strongly believe that, then you could get a forensic psychologist to evaluate the children and to see exactly what's going on, if there is any signs of disparagement or alienation or anything like that, which, there are cases that's worth doing, because I do see it quite often. But sometimes parents make a financial decision as well. If they can't afford it, they're not going to be able to do it. So
now this is what I've heard and read about, and I even discussed it with you, if it's actually accurate. Let's say one of the parents is licensed by New York State, be it a doctor, be it a police officer, a cosmetologist, a hairdresser. They have to have certain certificates. A lot of times you hear about, or you read about, or it's sensationalized, that the parent will make up some type of allegations that, whether it's Child Protective Services potentially come down, their license could be in jeopardy.
Of course.
And they use that to kind of say, well, then give me the children, without any issue, and we'll just fight about X, Y, and Z. Do you see that? I mean, do people actually...
Well, it's not the smartest thing, because, if
so
you go after, it happens all the time, but you go after someone, you have to just think about 5 steps, 10 steps ahead.
Financial consequences.
Financial consequences. So he loses his job, or she loses her job. How are you going to get child support? You just have to be like, you have to think reasonably. You got to keep the emotions out of it. And you have to understand that, conduct like that, unless it's warranted, calling Child Protective Services. And if you keep doing it, you're only damaging yourself, because there's going to be no findings. And when there are no findings, and you keep doing it, and it happens, whether it's an anonymous caller. Well, anonymous callers are my favorite. They call out of nowhere, out of the blue, to say, oh, he hit his child or something.
Meanwhile, there's never been any allegations,
no
or CPS
allegations,
or police there for 20 years.
And she says she didn't do it. And she says, or he says he didn't do it. At the end of the day, again, family issues are extremely sensitive. It's like no other area of law. And I've done various areas of law, and I know, and I came back to divorce and family law and wanted to do the entire practice devoted to divorce and family law. And the reason is I like to interact with clients, and I want to make sure I feel like I'm having an impact, hopefully always positively, but, I don't make the decisions. Judges and referees and magistrates make decisions. So clients need to understand that. But we fight wholeheartedly for their cause. And I'm a very strong advocate for them. And, at the end of the day, that's what my job is, to advocate my client's side.
But sometimes advocating, it seems, could be opposite in the way you think.
Yeah, and you know what? The best thing...
What do you do in that
The best thing, and the best attorneys on Long Island or New York, they're going to be straight up with their client. And you have to be able to control your client. Day in and day out, a judge will be in chambers with judges, and what they're going to tell us is try to settle your cases, because you're going to have a better outcome. Now, we've had judges give decisions. Clients are not happy with it. Now they want to appeal the decision. So I believe that the judges are absolutely correct in telling us as advocates for our clients and each respective side that at the end of the day, settling a case is much better than taking it to trial, because then it's out of our hands, it's out of our clients' hands, and some feel exactly what I'm telling you. And
you've saved a lot of time,
money,
heartache.
Yeah, absolutely. And you know what?
You can move on with your life
just
quicker.
From a settlement, I think it puts closure to, for example, a divorce case or a family case. Because the two of them have finally sat down and reached an agreement. Whereas when a judge makes a decision, whether it's favorable to one or not the other one is still fired up. You understand what I mean? At least this way you've made the decision. And you don't want to keep running, if it's family court for custody, you don't want to keep running to court throughout the child's life. And again, Custody is up to the age of 18. Child support is up to the age of 21, unless otherwise agreed. However, you don't want to, if you have a 3-year-old child, for 15 years, you're going to go to family court for every time you want to take your child on vacation?
That seems ridiculous.
Yeah, but people do it. People do it, and you know what? They need a strong attorney to be very upfront with them and someone who can let them know exactly what's going to go down. Because if they don't, if they have someone that's just listening to them, let me explain something to you. They're billing them, and they're going to be out of a lot of money and not with the outcome they expected.
Well, I want to go back to something you mentioned before. You said sometimes it's in family court, sometimes it's in Supreme Court. What's the difference, and when is it in each
Well,
court?
here's the thing. Generally, when you have a divorce, I mean, always when you have a divorce case, you're going to be in Supreme Court. Okay? Family court is for custody, visitation, orders of protection, child support, on those types of matters, relocation, but they are going to be basically heard independently. So when you're in Supreme Court, the Supreme Court judge has the jurisdiction to hear all of the issues of your case.
Everything, what's in family court too.
Yeah, but you can get it transferred from family court or consolidated into the Supreme Court case. However, family court will basically touch up on each issue, generally speaking, independently. So, magistrates hear what's called child support cases. They deal with the money. And on custody and visitation issues or relocation issues, you're going to have referees. But on relocation issues, generally, they have family court judges. But because there's so many family court cases, the judges don't hear every case. I mean, if you appeal a decision, right, then it's going to go to the judge, and the family court judge will make that determination. But again, Supreme can handle all of it under one umbrella.
Well, this is also interesting. I was just thinking about something. Let's say the spouse that owes child support or maintenance just says, I really don't care what the judge or the family court or any court says. I'll pay you when I want to pay you. And let's say they have a license issued by the state of New York. Could that license actually be suspended?
Absolutely. And that's when a parent, you certainly grab their attention. If they're going through support collection unit, which means the money is getting withdrawn automatically from their paychecks, then that's less likely to happen unless they become unemployed. And once they're not paying child support, then the number one thing is you lose your driver's license or you lose your license to work in the state of New York. So child support is they take it extremely seriously, and you can lose your livelihood, your ability to work or your ability to drive. And we've had numerous clients come in with hundreds of thousands of dollars of arrears. Eventually, they're going to have to get paid. You cannot discharge child support arrears in bankruptcy. You can't get rid of it. It's always going to be with you. So thinking that you're going to get away with something is not a strong argument in regards to child support.
Now, here's an interesting question on child support. Just now, with the composition of the U.S. now, and even people in New York and Long Island, could it affect your immigration status?
Well,
let's say
immigration asks you certain questions. If you owe child support, then you're not going to get your citizenship. We do have people in my firm that do immigration law. So I am a bit familiar with it. I used to do it years ago. But what it is there's certain things in immigration that they're going to ask in the application, depending on the green card application or the citizenship application.
Okay.
In the citizenship application specifically, you have to prove, if you have a child, because you would have to put in the application, you would have to prove that you do not owe any child support. Now, people are like, if I don't owe it, how could I prove it?
Well, what does proof mean? Do you have to get a letter from?
You would go to Social Services Department of your county, and you would get a letter that says, running, this individual's name, he does not owe any money for any child support obligation.
So it actually is an important thing that actually is checked.
Absolutely.
And could prevent you from being a citizen.
Most people don't know about it in regards to their citizenship or green card, but absolutely.
Wow, that's interesting. Now, really, immigration really hits every area from
well, divorce and family law hits every area, and doing as many areas of law that I used to work on. I used to be in the corporate field. I used to be in bankruptcy, done foreclosures. All of that knowledge has made me able to represent my clients better because I know a lot more about businesses. If a client has a business going through a divorce, bankruptcy, financial decisions that have to be made, foreclosures. In Long Island, many of the cases right now, they stop paying the mortgage. So what happens is they stop paying the mortgage, house goes into foreclosure, neither party wants to fill out the paperwork with the bank. So there are so many cross relations with these cases in divorce with other areas of law. So it's very good that I'm fully versed in other areas of law.
Seems like you have to be with the family.
You do.
Family and divorce.
Well, because you don't want to go to your family lawyer and then he says, well, I don't do foreclosures. Go see this foreclosure lawyer. Now you're going to pay him a consultation.
Same with I don't do immigration.
Go see your immigration lawyer. Absolutely. So having a firm that really has knowledge in a lot of various areas is extremely beneficial to the client.
Well, okay. Well, Al, again, we didn't get to everything. I appreciate your coming in. And the next show, Al, I want to get you back, and I want to talk about net worth statements.
Okay, very specific. I hope you remember
yes,
it for
very
the next
specific.
show.
I will remember that because that's a very critical part of a case, and we'll talk about that next time. Once again, thank you for listening to Legal Straight Talk.
Thank you.
Hi, I'm Jerry Parisi. Welcome to tonight's version of the Long Island Filmmaker Show, now known as the Filmmaker Show. Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.